Welcome. I am Bridget Lake, president of the Oviedo Winter Springs Regional Chamber of Commerce, and we are here today understanding estate planning in time of crisis with Attorney Sarah Geltz. Now, first, let me mention a few chamber announcements. Tomorrow, we have our education update luncheon on Zoom starting at noon. And we also have our 33rd annual golf tournament on November 20th. It's at Twin Rivers Golf Club with a 7:30 a.m. registration. If you're interested in playing or sponsoring or donating a raffle prize, please be sure to reach out. Our annual golf tournament benefits the Oviedo City Church Scholarship Fund, helping Seminole County Public Schools graduates further their education. And now, let us welcome Sarah Geltz. And first, I'd like to thank our sponsor today. We have Kendrick Law Group. Kendrick Law Group is a boutique law firm located in Maitland and is completely devoted to the clients they are privileged to represent and strive to effect the best possible outcome for each and every one. They have built their practice around long-term relationships and trust amongst those they represent, as well as a rich network of other lawyers and business professionals that are available to them for collaboration. They provide legal assistance in family law, business law, civil litigation, contracts, probate, real estate and closings, wills, trusts, and estate planning. And now we have Sarah Geltz. How are you doing today?
I'm doing well, thank you. Thank you for having us today.
Thank you for joining us. I'm going to do your quick intro here. We have Sarah Geltz Esquire is a senior partner in the Kendrick Law Group, owner of Champion Title and Closing, and co-founder of the Hope for More Foundation. She received her undergraduate degree in business administration from the University of South Florida and spent the early part of her career working in marketing, medical sales, leadership development, and sales training. With the support of her husband, Sarah decided to pursue her true passion and obtain a Juris Doctorate degree from Barry University School of Law, graduating in the top 10% of her class. Sarah focuses her practice on transactional legal issues, including asset protection, simple and complex estate planning, contract negotiation, drafting and interpretation, business formation, transactional real estate, and healthcare. Sarah is driven to give back to the Central Florida community. She is the current board chair for the PACE Center for Girls and chairs the Leukemia and Lymphoma Society Man and Woman of the Year campaign. Sarah also focuses her time and support with Advent Health Champions for Children, Make-A-Wish Central, and the American Heart Association. Thank you so much for joining us.
Thank you. Thank you. So what we really wanted to kind of talk about today is, what everybody has been talking about is the crisis has the COVID pandemic, all of that has really caused a lot of people to start to think, do I have everything that I need to have in order? It's advantageous to be proactive with your planning, but it very rarely happens. 9 times out of 10, I would say that clients who are coming in to address any type of estate planning, they're reacting to some event. So here now we've had in 2020 a global pandemic that has had everybody look to what they need to do to get their affairs in order, whether they're healthcare workers who, have a continual fear of being exposed to COVID-19, or whether it's just you've been home now thinking about, do I have everything in order in case something happens? And what should I do? If I have to do something right away, what are the most important things that I need to take care of? We've been fielding a lot of those questions since March. A lot of it has been, do I have everything in order? What should I be doing now? What can I do? What's most important? And we've really kind of tried to narrow it down to people as far as what you should really be thinking about, what you may already have in place, and what estate planning means generally. I'm going to go ahead and share my screen and kind of just talk through some things, see if I can figure out a slideshow. Okay. When we talk about estate planning generally, people, first of all, one of the biggest things that I get is what is an estate? I don't have an estate. Well, everybody has an estate. And what I tend to say to people is it doesn't really matter if it's $5 million or 5 sticks of gum, it's yours. And you should be in the position to decide what you have and where it goes. And it doesn't necessarily mean you have to make things exceedingly complex. And estate planning doesn't only refer to when you pass away. There are a few really important documents that I always try to talk people through, and some of them are important during your lifetime, because estate planning covers not only what happens when you pass away, but what happens in the event of your incapacity. So to me, and I'm going to kind of skip around on this list a little bit, 2 of the most important documents that you can have, and one of them will kind of combine, durable power of attorney is your financial power of attorney. We're in a society now where nobody can really act unless you are on an account with somebody. Nobody can act on anybody's behalf without some sort of authority to do so. And that's what this document is. You know, even my husband and I, we have joint bank accounts, but I also have an account that is solely in my name. If something happened to me or I was incapacitated, he would not be able to access that account if he needed to, or make any changes or do anything, or online banking, without some authority. And that's what this document does. The durable power of attorney will grant whoever you name as your agent in fact, is what they call it, the authority to act on your behalf. And it can be banking, it can be signing a tax return, it can be as simple as unlocking your cell phone. Apple is not going to give your password to just anybody. They want to know that they have the authority to open that up. And we are in a very, very digital society, especially this pandemic is an example of how digital we are. If you had to bank online and you're not physically going to a bank where they know you, you can't access that or get a password to conduct any transactions, brokerage accounts, any of those things without proper authority. So this durable power of attorney will allow you to name 1 or more people. You can name people in succession that if you are incapacitated or unavailable, that are able to act on your behalf. I probably thought I would never have to use it. I actually had to use power of attorney for my mother. And it's kind of a funny story in that she left and went to France. She went to Paris a couple years ago when we used to be able to travel. And the last thing I told her as she was getting on the plane was, when you get to New York, turn off your roaming data. You can still get on Wi-Fi, do all those things. Well, she didn't. And she got to France and ran through all of her minutes within the first 24 hours. And I was getting frantic phone calls saying, can you go fix my plan? Well, I'm not on her plan and I'm not an AT&T customer. So I was trying to simply give them more money. And I was not able to until I physically brought the durable power of attorney down to the store to show them that I had the authority just to put more money, because I was making a change to a contract that she had. So that was eye-opening for me, because I thought for sure they would just let me give more money, but no, they wanted the power of attorney for that. So those documents are really important. I always tell people, we have a lot of people who move here from other states. State laws vary. If you have it from another state, it is important to kind of get it looked at, make sure that it is adequate or it meets Florida requirements, because Florida laws are a little bit different. They're very inexpensive documents to create, less than $200 to do the powers of attorney. It's something that, if somebody asks me, what is critical, what do I need to have? The durable power of attorney and then the medical living will, health surrogate documents. I think those are the 2 documents that everybody needs. I also get a lot of questions sometimes, well, can I just go online and get a form? You can, you absolutely can. And for some people that is the right fit. I always encourage people to have, even if you've done that, have an attorney look at that. Most of the time consultations, especially in our practice, are, we will have a free consultation with anybody and review your existing documents, because again, those forms don't always account for specific state law, and there are clauses within them that bear explaining when you're going through and signing, and you don't always have the benefit of knowing what you're signing or what powers you're granting or not granting when you're just kind of going off of an online form. So if you did nothing else, I would say have your durable power of attorney, and then these next two documents, which are often combined in one, the living will healthcare surrogate document is your medical power of attorney. It is probably as important, possibly even more important than the financial power of attorney, because that is articulating and making your wishes known for any healthcare scenario. So the living will portion is basically your advance directive. It's you stating what you want to happen in the event you are in an end of life situation with no possibility of recovery. Do you want to be maintained on life support? Do you have any special considerations? Some people, different religious or different beliefs may have different considerations on how they want to be maintained. That allows you to articulate it, because there is the possibility, if you are in a terrible accident or you go into a hospital unconscious in an ambulance, you can't fill out the DNR that they ask you to fill out every time that you walk in. You want your wishes known. I advise people generally when we draft these, after we draft these documents, especially this one, take it to your primary care physician. Let them scan it as part of your medical record. So then when your records go somewhere, your wishes go with them. So that the living will portion is your advance directive, but then you also can designate a healthcare surrogate, somebody who can make decisions in the event that you are incapacitated, not necessarily in an end of life situation, but if you are unconscious, in a coma, patients with Alzheimer's, any reason, substance abuse, any situation where you cannot make a decision for yourself, you have to grant somebody the authority to make those decisions. And you can expand or limit their decision making. And then it's also important, I almost always include, unless I'm asked not to, a full HIPAA release with that. Because not only do you want them to be able to make decisions for you, but you want them to have the information that they need to make those decisions. And you don't want whatever facility you're in, or you're saying that they can't release their protected health information because you are not authorized under HIPAA. Another really important part of this document that people don't think about is I have my two stepdaughters are both in college. If you have adult children, anyone over the age of 18, it's really important that you have these documents for them as a parent. We often send our children away to school. If something happens at college and you have an adult child who is hospitalized, they will not automatically release information to you by virtue of being the parent, because your child is now an adult. So it's very important with adult children, kids going away to college, anyone turning 18, that they have these documents in place as well, so that the parents are able to access the information that they're going to need. If nothing else, if you do nothing else in times of crisis, those are the documents that you need. That can all usually be accomplished for less than $500. Then you get into, okay, now we're talking about you have incapacity. What about your stuff? What about afterwards? What if when you pass away, how are things going to be distributed? I tell people everybody has a will in Florida, whether they know it or not, because even if you don't have one, the state of Florida has one for you. It's if somebody passes away without any estate plan, there is a scheme of intestacy, they call it. So Florida will determine how your assets will be distributed in the probate process. There are different categories of assets, and this is what there's some very simple ways to make sure you have your wishes granted or taken care of. There's probate assets and there are non-probate assets. And at the simplest level, your probate assets are your stuff, and your non-probate assets is everything else. So anything that you can name a beneficiary on is not going to be subject to probate. So your retirement accounts, brokerage accounts, life insurance, anything where you can name a beneficiary, it's important to do so and regularly check that to make sure that it's up to date and reflects your wishes, because that will go where you want it to go. There are instances where those will become probate assets, because if you haven't updated or named a beneficiary, or in some cases, if you've named a minor who can't accept that as a beneficiary, those assets will then become subject to probate, which is where some mechanisms like a trust or some more advanced planning can come in. But probate assets are going to be governed by your will or intestacy if you don't have a will. And what I like to remind people of is probate truly is a voluntary process. You can avoid probate with some proper planning. And in most cases, I don't know that I've ever had a client who has willingly said they want to go through probate. Probate can be lengthy and it can be expensive. It can take anywhere from 12 to 18 months on average. And the process is designed not to protect you and your heirs, it's designed to protect creditors. The whole point of probate is the state is proving that all of your creditors have been paid, and then your assets can be distributed to your heirs. So the entire process is designed around corralling your assets, allowing creditors to come forward, making sure that people are paid, and then determining how any remaining assets are distributed to your heirs. The will is very important because it allows you to say how you want things distributed at the end of that process. It allows you to name guardians for children. Some types of wills will allow you to create trusts via the probate process. But without it, that probate process is still going to carry on, but it may or may not be what you want. Most of us, it happens a lot with blended families. So now I have 2 stepdaughters. My husband and I have been together since the girls were very young. And we also have a son. My son is 6. My intent is to have all 3 children treated as if they were my own. If I don't articulate that, that is not what's going to happen. If I were to pass away without any planning in place, my husband would take 30 to 50% of my estate, where most people think that everything goes to your spouse, which isn't necessarily. And then my 6-year-old son would get everything else, and the girls would get nothing, which is not my intent at all. So I have to make sure that I say what I want. Either way, the probate process would happen with that will, but at least with a will, I'm saying exactly what I want to happen at the end of that process. Wills can be very simple. They can be very complex. You can approach it any way that you want. What's going to be governed by that will is things like your house, any investment properties that you own, your stuff, your furniture, your jewelry, your fishing poles, your cars, anything that you have like that. I have clients that have, and it's not as common anymore, that I had a client that brought me a shoebox full of paper stock. That would be a probate asset. What we did there was get it cataloged in a brokerage account that she could name a beneficiary on, but she really had a shoebox full of old paper stock. So things like that are going to be part of your probate estate. And again, where that will becomes very important is you can give powers to an executor or a personal representative, they're called in Florida, that are able to do things for you. You can give your personal representative the power to sell and move assets, which is beneficial because oftentimes the big ticket item in a house or big ticket item in an estate is your home. If no one has the power to sell your home, or if there is no one else on the deed, that home is sitting, mortgages being paid, utilities need to stay on, depleting the assets of the estate while you're waiting for probate to be completed so that the house can be sold. There's some workarounds for that. I mean, obviously giving your personal representative a power of sale, but there's also, Florida is one of the states that recognizes something that's called a ladybird deed. That is basically a transfer on death deed where you can deed your property to someone else upon your death, rather than having to have it go through the probate process. It's not the same as having somebody else on your deed with you, which can with spouses, you're going to pass things, tenants by the entirety or joint tenants with right of survivorship where you want it to pass. But say you have an older individual that says, should I add my 2 children to my deed now? You can. It's not always ideal. If there is a mortgage on the property, then oftentimes there's documentary stamps associated with the transfer. You also incur some liability with multiple people on your deed, whether it comes to tax liability or in the event one person was sued, that is an asset of all of those parties, and that asset can be subject to any judgments against an owner. What the ladybird deed does is allow a person to retain all of their rights during their lifetime, which means they can sell the property, they don't have any liability for anybody else's actions, and then it automatically transfers upon death to the next person that you've named. Your remainder men, they're called. So that's a great option. that allows you to preserve all of your rights and not incur additional liability. Using a regular warranty or quitclaim deed, depending on your situation, may be just as simple too. If there's no encumbrance on the mortgage and you have no issues adding somebody else to it, a quitclaim or a warranty deed can be done very, very inexpensively. The biggest expense related to deed transfers is the intangible and documentary stamp taxes. I think I have pretty much talked about all of those. So another thing that we talk people through is when do I estate plan, or what do I do once I have an estate plan? I always try to tell people it's not static, just like you talk to your accountant every year or your financial advisor. If you don't, you probably should. It's always good to check in on your estate plan when there are life changes, when somebody gets married or divorced. A lot of spouses name their spouse as their executor or give them all of the powers or have them named as beneficiaries. When there's big life changes, you want to make sure that your documents appropriately affect those life changes. When you get married, if you have to change names, when you have children or additional children, you can write around a lot of things initially. We try to do that, include future children when we're writing it, include a automatic cancellation, upon divorce or annulment. You can write around a lot, but you do want to update and make sure those documents change, because oftentimes you're creating these documents when your children are very young. We get to know our children more over lifetime. There's life changes that happen. We have children, grandchildren, children get married. Those present some opportunities where you may want to make provisions for a child's spouse. You may want to make sure you're making no provisions for a child's spouse. You may want to leave things specifically to a grandchild. There's some tax benefits to that. There's a lot of questions that are good to ask. So what we typically try to do is, every year or two, you get a letter or an email from us that says, hey, let's chat. And sometimes it's a great conversation, catching up and seeing how everybody's doing. And sometimes it leads to some documents that need to change. It's also really important to be mindful of any incapacity issues, early onset dementia, injuries, anything that causes a life change that may potentially incapacitate you. That is a time to take a look at your estate plan and make sure that you have, appropriate successors in place that can step in and do things for you, update things, determine when you can and cannot act for yourself. So it is important to look at your estate plan, not frequently, but every couple of years, or when there's a big life change. It's not really a set it and forget it type thing. You don't want to have it and then 30 years later. I've had people come to me that say, I have a trust and it's fantastic, and it's been written 30 years ago, and it is a beautiful piece of paper, very well written, but they've never actually funded it or transferred everything into it. So there they think that they're avoiding the whole probate process, which is what a revocable trust is generally designed to do. And without properly transferring or funding it, you're still going to be going through the probate process, which is what you're trying to avoid. Checking up on those things every few years as you buy new properties or sell things, you can make sure that you are protected the way that you think you're protected. The process, I get a lot of questions about, well, I don't even know where to start. No one does. The most important thing that you need to do is work with people you trust and people that you like. I always tell people when they come in for a consult that they are interviewing me as much as anything else, and I would never be offended. You go talk to 5 attorneys. You have to find somebody that you are comfortable working with, that you're comfortable sharing information with, because you're getting into the nitty-gritty. Your attorney is going to know all the stuff, or they need to know all the stuff. It's not helpful when we don't know all the stuff and find out about it afterwards. But also make sure that your team, if you have one, is working together and communicating. I always, as part of my intake process, ask, do you have an accountant? Do you have a financial planner, insurance professional? And can I talk to them? Do I have the authority to speak with them? Because we need to work as a team. I need to know, what from an insurance perspective, what you have, who your beneficiaries are, financial planner. They need to know what we're doing with the estate plan. If we're able to communicate, I can get them documents that they need. They can get me documents that I need. And then everybody's on the same page. If all of these individuals are in silos, you run the risk that your estate plan is contradicting each other, and that can present problems down the road. The next thing is kind of the fact-finding process. We have kind of a questionnaire that guides you, and some people get very uncomfortable or overwhelmed by that. So I tell people, skip what doesn't apply to you. Let's sit down and talk through it, because we're going to talk about, what do you owe? What are your assets? What is your insurance? I mean, do you have a business? I work with a lot of business owners. Have you thought about how succession planning for your business ties in with your estate plan? Is it something that's passing down to family? What is going to happen with those business interests? Do you have any charitable giving that's important to you? A church, a scholarship, anything that you want to do? Who are you leaving things to? Who are you naming in these responsible roles? Because that's something really important to talk through, and it's difficult for some clients, and that's where you kind of explain to them that these are their documents and their decisions. I have a client that has 5 children that don't get along, and her initial thought was, I want all 5 to act as everything for me. I want them all to be my personal representative, all to be my power of attorney, all together, because I don't want to cause any more rifts, and then I want them to act unanimously. And I said, that is never going to happen. They can't even sit in the same room. So you have to really look at, when you're giving responsibility to somebody that A, can handle it, doesn't necessarily mean it's the oldest child, somebody who will be responsible and somebody who will carry out your wishes and be able to get things done. So, those are all important things to talk through. And oftentimes I end up recommending to people, at least, perhaps a corporate trustee is a better option, whether it's a banker or, some accountants act in that role, or there's actual trust companies, depending on the type of trust or type of role that you're in. Or some people will just say, I want my financial advisor to act as a co-trustee with my children to make sure that they're doing these things, or a co-personal representative, because I just don't think that they're going to have the bandwidth or the time to be able to do all of that. So those are all things that you can kind of uncover in the fact-finding process. And then from that, that's where we really talk. We talk about, what your needs are, what your future needs might be, how to best address it. I always tell people it is better to start with a manageable estate plan, durable power of attorney, living will, health, surrogate. If you are not ready, if you are newly married, no children, you may not need a trust. I'm not in sales. My husband is, and this is not a sales type pitch. It is what works for you, because it is much easier to build on your estate plan over time than to create this complex plan that you don't understand and have to unwind it. So, it may be we just get incapacity documents in place in a will, and maybe that in a time of crisis, when you have nothing and you want to get something in place, that's what I would recommend you do. Make sure that you're covered, make sure your beneficiaries say what you want them to say, and then talk to, as you acquire more assets or things that would be subject to probate, maybe that's the time that you start looking at creating a revocable trust. Or if you have multiple investment properties and you're worried about liability, maybe then we start looking at LLC structures. And then you want to make sure that your business, it should be a relationship that you have for a long time and that you build on. So that whole team communicating can then make recommendations for you. This is what I think you need to do right away. This is what I think you can wait. This is, name guardians for your children. If you have children, I think you almost always need a will, because in the event something happens, you want to name who your guardians would be. So then after reviewing what everybody's talking about, we actually create the plan. I find it much easier for me to draft documents and then sit with the client and go through the documents than to keep it very, very abstract. There's a lot of legalese in the documents that you can, that once you explain it and break it down into plain English, it makes a lot more sense. So I like to sit with people and make sure that the documents say what they want them to say, that we understand the powers that are given or where things are going. And there's almost always, I've never had a draft first time say, yes, it's great, because then I would know the person hadn't read it. But, we get it to say exactly what you want, and then you execute it. And in Florida, there is no recording of wills or anything unless you wanted it that way. So your documents are valid and in effect when they're signed. They have to have 2 witnesses, and it is recommended to have a notary. Then you have your self-proving affidavit, and those documents are valid that day. The way we typically do things, we give our clients their original documents in a binder along with copies, and then I create an electronic Dropbox where they have PDFs of those documents if they ever need it, because oftentimes you're sending a power of attorney to a bank or a living will health surrogate to a physician. You have access to that to be able to send it to the people that you have, or also not send it, because when somebody has that power of attorney in their hand, they are able to act on your behalf. Oftentimes what we will do is notify the person who's acting as the agent that they've been named, and if they need the document, they can come to us and get it. So they have my contact information. If they ever needed the power of attorney, we have that Dropbox created and we can send that to them. And it's not just me with the access to that in case I was never not available. We create where they can have access, and we would know if somebody accessed it to prevent fraud. We have, a lot of that is, we have a lot of elderly people in Florida that don't necessarily have a lot of family, and they're giving power of attorney to a neighbor or somebody at church or somebody that they met, and you see a lot of elder abuse that way. So we try to take as many precautions as we can to protect people, and then review them as needed. That's kind of the big step to the process, and